In order to file a formal lawsuit for a wrongful death, the first thing that has to happen is that there has to be an executor or an administrator or an executrix or an administratrix, and those suffixes involve whether it's a male or a female. But someone needs to be the appropriate representative of the estate. So that happens by going to the courthouse of wherever jurisdiction the person was living at the time of the accident and submitting an actual will, if there was a will, and if there's not a will, filling out an application for the right to control the estate. And again, it follows according to law who has the right to control the estate. In the first instance, it would be the spouse. In the second instance, it would be the children. In the third instance, it would be the parents. And then it would go on from there. However, during the course of that process, anyone who's entitled to represent the estate can renounce it. That means that they don't want to be involved in that responsibility and they could pass it on to the next level of person. So once you have a representative of an estate, then that representative of the estate then is in a capacity to hire a lawyer, and then that person, that lawyer, would then bring a lawsuit both for wrongful death and the damages associated with that, and for the survival action. The survival action is the action on behalf of the estate, where things like pain and suffering, both before the person died, their wage losses, both past and what they would have earned in the future. Those two elements would go into the estate, and it would pass just like anything else that was in an estate that was inherited. So it's a relatively complex lawsuit to file. It has different counts for different elements involving one death.